Your Honor, there are three case numbers. I represent Mr. McCoy in the two that are from 2020. That's 20 CF 3136 and 20 CF 4047. If you'll recall, Your Honor, Mr. McCoy represents himself in 23 CF 204.
Mr. McCoy, I've already found that you're competent to represent yourself in that case. Do you still wish to represent yourself in that case?
I do.
Mr. Williams?
Your Honor, we have a new state attorney assigned in the two cases I'm representing him in. And I believe the state probably needs a little time to get acquainted with the case. We've talked informally. It's my understanding he'd like to take it to another pretrial.
Yes, sir. Well, Mr. Clark, can I say something, sir?
Yeah, you can address, yes, sir, address your case also, the one you're representing yourself also.
Right. Yes, sir.
Devonte McCoy is using one of the most dangerous courtroom strategies. There is self-representation combined with sovereign citizen-style arguments. He repeatedly demands explanations, operating under the belief that the court must justify its authority to him. In reality, once a bond is revoked, the judge does not need his permission or agreement to keep him detained.
On that case,
Yes, for the record, that's 23 CF 204.
yeah, well, I got a couple motions I want to file on them, but
Okay.
about that case, so can I ask why I'm being held without bond?
Sir, Mr. McCoy, we've gone over that. I revoked your bond, I believe, in the K2 case numbers because of the arrest. So I think we've already adjudicated that and litigated that all. I'm going to litigate it. But that's why you're being held without bond.
I mean, is there a reason though, sir? Like,
Yes, sir,
because
yes, because you were out on bond and you picked up another charge.
I'm innocent on that charge, Mr. Clark. And I got the
Absolutely, you're presumed innocent on all the charges. So I assume you're not admitting that you're guilty on the two charges that you're out on bond on.
Man.
You're presumed innocent on all three of the charges.
Can I ask that the state has filed a motion to hold me without bond, Mr.
No, sir. I believe the court. I believe, and I may be wrong. I may have done it on my own motion.
You had a hearing in February, I believe it was February 24th, and then you addressed it also at our last hearing on October the 17th.
There was an order of revocation of release, and that was done by the first appearance judge on January 18th. So that judge held a hearing and revoked your bond, or issued basically a warrant and held you without bond. So that, and I upheld that.
I understand, sir, but it's been since January. Is there a reason why you feel like I need to be held without bond?
Yes, sir, because you picked up another charge while you were out on bond.
Well, Mr. Clark, I'm just speaking real quick.
Go ahead, do it quick. Before we address that, I'm not making it any plainer for you.
Have a little patience with me, sir. I understand that judges, they should be patient with their client, with litigants.
Well, I'm as patient as you. I'm going to be patient. I'm going to treat you just like a lawyer. And I'm treating you just like a lawyer. And when a lawyer goes to repeating themselves or re-litigating something that's already been litigated, I give them very little short leash. And that's basically what I've done to you. I've addressed that so many times. I'm not prepared to address it again today. So if you want to talk about something else, let's move on. But I'm not going to reinstate your bond today. Okay?
This is where sovereign citizen thinking collides head-on with criminal procedure. McCoy keeps insisting that he's innocent, but innocence alone does not prevent bond revocation. When you release and pick up a new charge, the judge is legally allowed to remand you into custody, even before trial.
Actually, why, Mr. Clark?
Yes, because you picked up another charge while you were out on bond. That is
okay.
I know that you say you're innocent, and you've said you're innocent on.
Listen, I just want to say this one thing, Mr. Clark. One thing. We
Go
can
ahead.
move on to the next thing.
Okay.
Okay. What makes me different from the person that you released last month?
I don't know. I
picked up a driving on suspended license charge.
I got no idea.
He had battery on a police officer.
Listen to me. I'm not going to compare you to other.
Battery on a police officer.
I'm not going to compare you to other cases right now because I can't remember. It's not fair to me. I don't know why I did what I did.
I've been in jail. This case been going on.
Let's move on. I've answered your question. What else is there? Go ahead.
Sitting in jail for 3 years.
I understand. But tell me what else. You ain't sitting in jail for 3 years. This was the
for a few months when I caught that BS charge, but I got all the time.
Let's go. What else we need to do?
Set me up for a bond here.
Okay. December 19th at 9 o'clock.
Okay. Well, wait a minute. I ain't done yet. I still got some motions I want to file.
Okay, you can file them. Now, have you got copies for the state?
Yeah, I got copies for the state.
Okay,
too.
you need to provide Mr. I guess it's Mr. Ferrer.
Yeah. What about on my new case? Okay, on my new case, I never had a driver's license, right, in my life, and the fact that I'm charged with a felony is wrong, because driving without a valid driver's license is a misdemeanor, even if you are habitualized.
Hey, you need to file a motion.
Well, I got the motions ready right here.
You'll file it.
Okay, I'm about to file it. But my thing is, if it's already on the court's attention that the information that was filed on me was wrong, that's a fundamental error.
That's
impossible to
this
charge
is
me with
unsworn testimony. I got no idea, but file your motion, and we've got everything. We'll set.
We already been through that because on my charge before, on my case before, you already corrected that charge. So why is
Listen to me. I'm not arguing with you. This is a pretrial. I'll set your motions for December 19th if you want to file your motions now and get everybody ready.
right now? I'm filing. Okay.
Watch how the judge cuts him off. That's not disrespect. That's courtroom control. McCoy keeps trying to relitigate an issue that has already been decided. Judges don't debate their rulings. They enforce them. And every time he repeats the same argument, he only makes his situation worse.
What about my back to my representation thing that we had.
Okay.
Okay. I have a copy of my transcripts.
Yes, sir.
And you said that I expressly requested counsel. I got a copy of my transcripts to prove that that's not true.
Okay. Well, you on what case?
On my 23 case, I got a copy.
You represent yourself on that.
No, but you made me redo it. I had you
What
denied all my motions.
What is your relief? What relief are you asking?
My relief is that I want my motions to be heard that was denied.
December
under
19th.
Booker versus State.
Look, we're gonna set pre-trials for January 18th. Listen, Mr. McCoy, you're hearing this over with today. I've listened to everything I'm gonna listen to. We'll set your motions. If you want to file them right now, give the state their copies December 19th at 9 o'clock for the motion. I'm assuming it's a motion to reinstate bond. It may be a motion to
It's a motion for
dismiss.
motion to discharge and the motion for notice.
All right, file them, and we'll set it for December 19th. We're gonna set we're gonna set everything for January 18th.
Let me get my motions ready. I ain't ready to be pulled out yet. I got to get a state.
No, sir. That you can hand it to them, but this is you're hearing over with today.
I can't get them my motions.
Yeah, that's got nothing to do with it.
All right, I gotta get them ready.
You just let Mr. Devonte McCoy sit in the courtroom and get his paperwork ready, and let him file his motions and give his copies to the state.
You have a nice day, Mr.
Huh?
You have a nice day, sir.
You too, Mr. McCoy.
This case is a textbook example of why sovereign citizen tactics fail in real courts. The law doesn't change because you argue louder or longer. It changes through proper motions, established procedures, and admissible evidence. McCoy will get his hearing, but, until then, he remains in custody. Reality beats rhetoric every time.